On June 18, 2017, two Seattle Police Department officers respond to an alleged burglary at the home of Seattle resident Charleena Lyles. Aware of prior incidents between Charleena and the police, they chuckle and verbally agree not to let Charleena behind them or between them and the door. Charleena lets the officers into her apartment. They see Charleena's two youngest children in the living room. One is 4 years old, the other only 1 year. Charleena's 12-year-old sleeps in a bedroom down the hall. Minutes later, the officers shoot 7 times, killing both Charleena and her unborn child.
Why didn't you defuse this situation before you had to shoot a pregnant mother of 4?
She thought that she had been burglarized and she called for 911. Officer Anderson was assigned the call. There was a warning that came up. It's called an officer alert. And it called his attention to an incident that had happened 12 days prior, where she had had a mental health crisis, where it had involved making threatening statements and gestures to the police, but they were able to de-escalate it. So he knew that there was an officer safety caution and that there was a mental health problem involved. For that reason, he called for a second officer, who was Officer McNew. From there, they then had some decisions to make. What do we do? How do we go in? How do we approach it? We alleged that they did not do any of that.
I've been out here for another TV with the son.
Wait, is this the one with the 3 kids?
Yeah. So this gal, she was the one making all these weird statements about how her and our daughter are going to turn into wolves.
Oh, she didn't want to let them leave.
Yeah.
Oh, golly.
Yeah, that's what I'm like.
Don't let her behind us.
Just keep ourselves between her and the door. That was their plan. But even their plan of keeping themselves between the door and her doesn't happen because they separate. And one officer gets sidetracked. He's looking at the kitchen, and then there's some kind of a noise, and there's an interaction between Charleena and Officer Anderson.
Now, mind you, the first thing out of Officer McNew's mouth was taser. Less lethal was the option that immediately sprang to his mind.
The police have to carry a non-lethal, and Officer Anderson had chosen his non-lethal to be a taser. But against policies, he left it and had left it for more than a week in his locker.
They'd been trained on de-escalating knife attacks with tasers.
So when Officer McNew said taser, Officer Anderson said, "I don't have it." What makes it even more horrifying is that her children are there. 3 of them.
What option did they take? It's the only one they thought they had available to them, to shoot her. It means they showed up with no option other than to shoot her. These officers had not much of a plan, didn't follow the plan that they have, didn't follow policy, didn't follow training, didn't bring their mandated equipment with them, with which they could have de-escalated this case.
Those children need to know that their mother should not have died. She should have received compassion. She should have received resources. She should have received assistance. She should not have received 7 bullets. The civil case is a wrongful death case brought by the Charleena Lyles estate on behalf of her children against the City of Seattle officers Anderson and McNew.
We chose not to go to federal court. Instead, we went to state court and brought a negligence action, which allowed us to examine the acts of the officers leading up to it. So we were allowed in this case to make allegations that they didn't plan this properly.
This case was filed within a few months of Charleena's killing. And what happened at that time when we filed the lawsuit was we ran into one hurdle after another. In fact, we ran into so many hurdles that the case was thrown out of court and dismissed, basically.
The judge made a bad mistake and dismissed our case. She said there's no duty. It doesn't matter.
We then had to appeal it, and thankfully, the appellate court reversed the lower court and sent the case back to be tried. It was supposed to be tried on February the 7th, 2022. We have changed the law through the Court of Appeals, and we have changed the course, hopefully, of her children in giving them some resources to protect them as they move into the future. But most of all, the settlement recognizes the value of Charleena Lyles' life.
It's crystal clear in our law right now. Officers have to think about how their actions may precipitate injuries, and they have to take reasonable measures to avoid them and to de-escalate.